We are recording.
Hey, my name's James Pepper, Chair of the Cannabis Control Board in Vermont. Today is Friday, January 5th, 2024. And I call this special meeting of the Cannabis Control Board to order. So this is a special meeting, as I just mentioned. We're calling it to resolve two issues in which the board recently took an adverse action against cannabis businesses operating in the state. Not going to go too deep into the factual basis of each right now, but the first was a denial of an application for a violation of the one license type or one location per entity rule. The other was a notice violation for an unapproved transfer of a cannabis license and included a corrective action plan that took effect immediately. In both instances, the orders included steps that the affected parties could take in order to correct the violations and have the board reevaluate the decisions. So that's what we're doing here today. The impacted parties have worked with the staff here and come to a resolution. They've achieved the steps that were required of them. We're going to hear from our legal counsel. We're going to hear from the affected parties if they want to be heard. And then, depending on the circumstances, we'll decide as a board whether to kind of reverse our prior actions, uphold them, or amend them. Special meetings are meant to be rare, but in these instances, because of the expeditious actions of the impacted parties and given where we are in the calendar, we decided that it was appropriate to hold a special meeting to address these issues instead of waiting until our next regular meeting. So, why don't we get into the agenda then? Let's see. The first issue is around Be Well Vermont. And Gabe, do you want to give us a brief orientation to that issue?
Sure, thank you. So one of the board's most important licensing responsibilities under the scheme given to us by the General Assembly is the oversight of what we kind of call the one license rule, a statutory provision that a licensee and a person and the person's affiliates can only have control over one license at a time. That means that the application process in Vermont entails quite a bit of scrutiny of the financing and management of businesses that is not typical of other licensing regulation. In this case, Be Well proposed to and does propose to operate a retail establishment in Rutland. They put in an ordinary application for that. The staff observed some commonality between sublessor, the Be Well's proposed sublessor, and some other cannabis establishments, and that sort of created red flags and inferences that something might be connected between those in a way that caused problems for the one license rule. So the board, evaluating papers that it had been able to collect at its regular November meeting, came to the conclusion that on their face, the papers did create the impression that more likely than not there was affiliation between another retail licensee and the retail licensee that was applying, and on that basis, the board tentatively concluded that it could not responsibly license the additional retail establishment. At the time, the board was aware of the limits of some insight, and that we collect papers and we don't really have the ability to go out and interview people and find things out in the manner that you might if you had completely free hand and unlimited resources. So the board did sort of what one would do with that awareness. It wrote a proposed order explaining exactly why it proposed to deny the application. It didn't enter that order with finality, but instead invited the respondent to sort of explain, provide any details that might have eluded us. That has happened fairly impressively since. We heard from Be Well's counsel. We received sworn attestations both from the proprietor of Be Well, Karen Nash, as well as from the intermediary sublessor, who was the source of the potential connection. In both cases, they affirmed quite clearly and unequivocally that they have no designs on controlling one another's operations or influencing one another in any manner. The sublessor has explained a commercially rational reason that it would be a sublessor among, and that is that they're kind of in the business of fitting out potential retail establishments. And the most important thing that's happened is that Be Well, through its counsel, Mr. Fine, who's here with us, renegotiated its commercial sublease. And it took out elements that the board specifically found concerning in its proposed order. Specifically, those who were an entitlement to 5% gross receipts, et cetera, the kind of shopping mall style arrangement. And along with that would come an obligation to give considerable insight into one's books, the typical in shopping malls, not made in that kind of arrangement, but nonetheless something that would cause real concern about influence. So they changed those provisions of the lease. They have added some non-interference language and some language specifically around right to renew. The lease itself, I think, would be regarded as a trade secret, and so we mark it, seal in our records, and I'm not going to go into great detail about it because it's unnecessary. But it will suffice to say that the substantial steps were taken in the new language to address exactly the concerns raised in the board's proposed rule. With that in mind, staff has prepared a recommended final decision that is favorable to Be Well, on the basis that we believe that those concerns have been mitigated. All of those documents have been available or have been made available in a packet to board members so that you can scrutinize the new sublease as well as the attestations of the parties. So we have something for you that we think would be compatible responsibly with approving a license at this time. And I know you've done quite a bit of reading on background, so that's where we are. And I know I asked Attorney Fine if he could be available just in case the board has questions. I'm not really expecting that, but he is here with us.
Great. Any questions for Dave?
For me?
No. Thank
Okay. Anyone from Be Well, Karen or Andrew want to speak? No obligation, of course. Or Adam, sorry.
Thank you. I just wanted to thank the board for meeting today, and I'm just here available for any questions. But Mr. Gilman gave a good summary, so thank you for your time today. Can you hear me?
Yes.
Yeah.
Sorry.
Okay, great.
Yeah, no, thank you, and thank you all for acting so quickly on this, and kind of dispelling any of the kind of problems that we identified. I know it says that we can enter a deliberative session, but I know that we've also read all of the materials that were provided to us, and we've seen a revised proposed order that would vacate the prior, proposed denial and then approve Be Well for licensure. So, does anyone feel a need to begin in a deliberative session?
No, it's all very clear. Thank you.
Yes, thank you.
Okay, well then, is there a motion to approve the kind of proposed order that we received?
I have a motion, but I think that there's some specific language I should use, perhaps.
Oh, I'm sorry. I guess my suggestion to you would be that you make a motion that the board adopt the proposed final order set before you, vacating its proposed order and approving for licensure Be Well and its application.
So I move that we vacate the previous order of November and adopt the updated order as recommended by staff.
I'll second.
All in favor?
Aye.
Aye.
Aye. Great. Well, thank you, Be Well. Thanks for going through that process with us.
Thank you.
We'll move to our second issue, and this is In Re Oho Roho Cannabis Wholesalers and Vermont Roots Collective. Are you all right with kind of going through?
Sure, I'd be happy to. This one is complicated and it's kind of taken a bit of the month for everybody involved, and we appreciate their joining us today. On the 13th of December, right before the holidays, the CCB served upon Oho Roho and BT Roots notice of violation with immediate effect. It appended to it was a corrective action plan in order to cease and desist. The operative problem there was that it was discovered that the Oho Roho wholesale operation licensed by the board as an incumbent licensee had transferred control prior to approval by the board and issuance of a license to do that. Under your Rule 1, the day such a transfer happens, the license is considered to have expired. And VT Roots, although it's a corporation under the registered with the Secretary of State, has never been a corporation licensed with us. So this created a situation where there was no active license in sight. So it was the staff's obligation to send a cease and desist letter asking folks to immediately halt what they were doing and holding themselves out as being in cannabis commerce. Part of that order required as well that there be an inventory of what was on the site so that we could make sure that we understood where cannabis product was and how it was moving. I should say there was immediate cooperation from the folks involved. Although I'm sure it was very unpleasant to get that news, they complied fully and were totally cooperative with staff. This created a challenge, though, because typically when you do a notice of violation with immediate effect, aware that can have devastating commercial consequences to hold somebody up. There's a 10-day timer once somebody files a response, after which they're meant to be heard. And we could meet that, of course. The challenge was there was no license. And so we had the licensing staff then walk folks through really an accelerated process, everybody working very fast to try to put people through the necessary due diligence to make sure that we were in a position to have a completed license application for you to consider and approve today. In the ordinary course of things, it would have meant waiting until your regular meeting at the end of the month. However, as we sit here today, it's been 23 days since the submission or since the notice of violation. So we're looking at we'd be looking at more than a month and a half out of business, which no question could be devastating. So that's why this was fit for a special meeting. Staff got through almost every box checked in terms of the boxes that are mandatory to check before something can come before you, except one that's beyond our control. That is that the background checks required of principals and controllers go through a third-party service, and we don't control how fast they go through it. The folks here have, in good faith, submitted their stuff. They didn't drag their feet. They got moving on the process. One of them was moving on it already. Nonetheless, if we wait for that, it would mean an effective suspension that nobody intends. So the question before the board, in a sense, is whether you are comfortable with the corrective action plan that we have proposed in these documents to sort of patch those holes, mitigating somewhat the risk of having somebody who was not known be a new controller without the ordinarily required background check. Is that both of the new principals and controllers are sort of known quantities in the industry, and most important, have employee ID cards or pass the process to obtain an employee ID card through a background check system that is different and slightly less rigorous, but not trivial. And so I think there is reason to say that if there were concern, it would be known by now. And so this might not be responsible to do with people that didn't have those background checks already, but in this case, that might augur in favor of the board accepting the proposal that is a corrective action plan. When I say a corrective action plan, it's actually an agreement really by the principals that in the unlikely event something comes back that isn't expected, the board would be able to suspend the license without further process and protect the public in that way. Nobody expects that to happen, but I want you to understand that that's one of the things that you would be doing if you adopted the resolution. So that takes care of the licensing part of it. There are sort of two parts, and that's the licensing part. The other is that the violation itself occurred, and the respondents admitted it. It had a meeting with us here at the CCB, and then later that evening filed a response acknowledging the violation. It asked that certain factors be considered in mitigation. The presumptive penalty under your rule for unauthorized transfer is $10,000. Your rule 4.7, however, does instruct you to consider sort of what they asked, to consider mitigating factors and make adjustments according to what is just and fair based on what happened. As paragraph 6 of the proposed resolution specifies, it is felt that it might be appropriate to bring down that $10,000 amount, specifically looking at the factors in Rule 4.7. These folks had not committed prior violations. Violations were halted immediately cooperatively upon direction by the CCB. There were a lot of compliance checks with the interim compliance director going up there and looking around. There's probably no more scrutinized wholesaler in the state at this point. He did not have any concerns at the end. He had full cooperation with folks there. The principals have openly acknowledged some degree of mistake or neglect, but they didn't act with the purpose or hope of deceit. As a matter of fact, the purchase and sale agreement that established the violation was submitted to the CCB by them as an applicant. And so if one were hoping for a long running deceit, that isn't something you want to do. So for all of those reasons, it is felt, and also consideration of the lost business time and revenue, more expensive than the penalty is being out of business for that period of time. So in light of all of those mitigating factors, which the board is directed to consider under 4.7, it was felt that a $5,000 rather than $10,000 penalty would be appropriate. The respondents requested that an option to pay that installment wise. That's very typical. You see in other agreements where we've done that, and so that was proposed as well. So what you would be approving together, or you would actually be approving in two steps. You'd have to assess: do we want to accept the corrective action plan, treat this as a complete application, notwithstanding the absence of the background checks based on the agreement? And then second, is the penalty appropriate based on the factors in 4.7? So that's where we are and what you have before you. If you have any questions, I'd be happy to answer them.
My only question is, so if I'm getting this, and I know this is not relevant necessarily, but moving forward, is this company going to be called Oho Roho, or is it going to be called Vermont Roots Collective?
The principals have been pretty clear about their intention to rebrand as Vermont Roots Collective. One of the elements of the corrective action plan that we were actually discussing with them last night is that the licensed entity is Oho Roho Cannabis Wholesalers. That's who the insurer thinks they're dealing with. That's who all the business partners think they're dealing with in a formal sense. It is common to register and assume business name with the Vermont Secretary of State and do business publicly under that name, and they can do that. Our agreement is that if they did, this is section, I think A, or section IA(2), is that if the new principals intend to assume a new business name other than or to rebrand to reflect ownership by VT Roots and the latter's principals, the licensing corporation will complete appropriate processes in a timely manner, including registration of an assumed name with the Secretary of State, and comply with such directives of the CCB as may be appropriate to prevent consumer confusion. So really the CCB's interest is in making sure that people know what company they're dealing with and can tie the person they're dealing with back to a company license that we issue, as long as there's no confusion and the commercial law is complied with, then it's not really our interest to micromanage how people are marketed.
Any other questions for Dave?
No, thank you.
So, Ryan or anyone from Vermont Roots / Oho Roho want to say anything? I would want to just at the outset thank you for working so closely with our staff over these past few weeks to get this resolved.
Just wanted to thank you as well. I know this is a little bit different, so we appreciate it.
Thank you.
Thank you.
So we've all had a chance to review the kind of underlying documents and the agreed disposition and the corrective action plan. Do we need a deliberative session to review anything?
I don't.
I don't.
Okay. All right, well then, if everyone feels comfortable, I accept the motion to approve the agreed disposition and corrective action.
I move that the board accept and approve the agreed disposition and corrective action plan proposed by respondents and staff, and that on the basis of that approval, that the board approve the underlying application of Oho Roho Wholesale Cannabis to operate under the ownership and control of the new principals.
I will second.
All in favor?
Aye.
Aye.
Aye. Okay, well, thank you all.
Thank you
So
very much.
just- Welcome.
Okay. Thank you, guys.
This is a open meeting. We're following the open meeting laws. If anyone would like to make a public comment, please feel free to raise your virtual hand. I don't see anyone that's joined by phone, so we'll just keep it to that. All right, I'll close the public comment window. Well, Kelsey, do you see anyone who's joined by phone? If you have and you'd like to comment, *6 is the way to unmute yourself.
I was just gonna say, I don't see anyone.
Okay, great. Well, I'll close the public comment window. And is there anything else we have to do?
I think you've taken care of all of it in your two motions. So.
Okay, all right. Well, then I will adjourn the meeting. Thanks everyone for joining, and thank you to everyone involved for kind of getting these issues resolved. These are like the two fundamental pillars of our system, the kind of knowing who is licensed and who's not, and making sure we're not violating this one license per entity rule. So, thank you.
Thank you.
Thank you, guys. Have a great weekend.
Thank you.